everybody. So again, I'm David Terrace. I'm the head of our Federal Criminal Defense practice here, and it's my passion. It's what I've always wanted to do. It can be daunting, but it can be done, and it can be done earlier in your career if you're able to get the guidelines down and to take some risks. So we're going to talk about that. And this presentation, Adam kind of touched on it before. It's going to be very much a practitioner's guide. We're going to spend time on a lot of concepts that if you've been practicing in state court, if you are a criminal defense attorney, a public defender, or in private counsel, but haven't been in federal, then you're really not going to see so much of this. And it's things that I probably wish I would have known when I first jumped right into federal practice. Trial, or Adam went through the overview, trial process, filing motions, some nuances there with federal court. Mostly it's knowing knowing the judge, knowing the prosecutor, knowing what they like, and following the local rules and procedures. But it's the investigation stage, some of these things that are not written down anywhere that we're really going to focus on. So starting with investigation, of course, if a client comes to you and they've already been arrested or they've already been charged, then a lot of this might be superfluous, but we do get a lot of clients who come to us during the investigation stage because of how the federal system works. It's built on, very often, not built on state court where you see a crime committed and you're arrested and you have first appearance the next day. Federal law enforcement and Department of Justice, a lot of times they take their time, and we want to get in as early as possible. Investigation is actually one of the areas where the defense attorney can probably do the most good, believe it or not, and we'll talk about that. So it starts with the client interview. As Adam said, we're not interrogating the client, but we really do have to gather as much detail as possible at that stage, at the client interview, because timetable, we don't know where it's going to be. Are we 2 years out from an indictment or an information? And we'll talk about the differences later on. Are we a week out? Are we a day out? We just don't know. So we have to build as much as possible. It's not like in state court where client comes to hire you and they said, yes, I was arrested yesterday. And you say, okay, I'll have a probable cause affidavit pretty soon online. Not very, very rarely does it ever work like that. So after the client interview, after you've determined and you've gathered as much information and you've built that trust with your client, next step is reach out to the prosecutor or don't reach out. And 99% of the time, the right thing to do is reach out. And so we'll definitely talk about that. So a lot of goals in the investigation stage, or sometimes we call it the pre-filing stage or pre-arrest stage. Your goal is really to be a sponge. So when you're having that initial contact with law enforcement, either the agent who's investigating or if there's a prosecutor assigned to the case, we'll talk about the differences between those two concepts and similarities as well. You just need to gather as much knowledge as possible. Just like you're doing in the client interview, you're kind of interviewing the prosecutor and the agent as well. You want to learn as much as you can about the case from the client when you meet with them, but then when you go and talk to the prosecutor, something that I do, a practice tip very often is sometimes I reaching out and saying, hey, I don't know anything about this. Just I gotta advocate for my client. We got to make some big decisions here. Please just tell me as much as possible, because sometimes a prosecutor or an agent in the federal system will keep it close to the chest for several reasons that we'll discuss. So there's different creative and tactful ways of squeezing information in the investigation stage. So you want to get as much information as possible, and you want to be able to set your client's expectations. I mean, any state, federal, any criminal defense practice, managing and setting expectations as much as you can. We don't have a crystal ball, but as much as you can is super important. Are they potentially going to be indicted in a week, a month? Do they want to have a sit down with our client? Do they want our client to cooperate with the federal government against somebody else? All things that we'll discuss, but we have to really figure out what the government's intention is prior to filing charges the best we can. And then, of course, the ultimate goal, which is difficult but can be done, is to dissuade the government from concluding their investigation with a criminal charge, an arrest, and then a charge against our client. It's possible, and we'll talk about some of the ways, and it's very dependent on how soon the client comes to you and where the government is in their own timetable. So how do we achieve these goals? First, just shielding our client, being our client's voice, reaching out to the prosecutor and saying our client is invoking their right to remain silent, but we'd be happy to speak with you and facilitate your investigation in any way possible. But please stop calling my client. A client has a right, as we know, under the Fifth Amendment to remain silent, and they have a right under the Sixth Amendment to have, and 14th, to have counsel represent them and to be their voice, speak on their behalf, and to be present whenever they are questioned by law enforcement. And federal government and federal criminal defense, more than dealing with state prosecutors and law enforcement, are much more receptive to hearing from attorneys during the investigation stage, because the federal government, your client might be at the very top of the food chain, so to speak. Your client might be the primary or the conspirator in a scheme, or he might be the only person they're looking at for a specific crime, but they're always in the back of their mind trying to find the big fish. So we definitely want to be that voice for our client and present those opportunities. Asking the essential questions early on, same kind of questions that we ask our client: the who, what, where, when, why, and how. Finding out what agency it is, what crime are they investigating or crimes, where do the alleged activity take place. These are questions that we try to get from our client. Now we're going to try and get it directly from the one who's making these decisions. Where is really important. Sometimes we have a case that is being investigated. All the prosecutors, the Department of Justice trial attorneys, and the Human Health Services and Medicare investigators are based out of Texas, but the investigation is happening in South Florida. And we're trying to figure out, is this case going to be filed in Texas? Is it going to be filed in South Florida? We're based in South Florida, but we do have cases all throughout the country, federal cases. So where is super important. When did the alleged activity occurred? That's very important. Also, when can they give us any kind of timetable as to when they're planning on proceeding to whatever their next step in their investigation might be. That's, if you really can't get much else, just being able to tell your client you have a month before they intend to make a decision about a grand jury, you have a week, you have a day, or they're years away. That's super important to know, and to help manage your client and to build that trust as well. So the next thing, why my client, and this concept of witness, subject, or target, we're going to talk about in detail, but it's probably the most important concept of an investigation. Why are you investigating my client? Simple as that, but it's also very, very nuanced and complex. And of course, how is finding out. This takes time. It's not going to happen on the first phone call with the prosecutor or the second. If they intend to bring charges against your client, or they're investigating your client for a crime, as opposed to potentially them just being a witness to a crime, or even a subject, and we'll talk about the distinctions, are there ways that we can resolve this without criminal charges being brought? So we talked about the invocation of rights, right to remain silent and right to counsel. If we're nothing else, we're our client's shield and their voice. So we've said that. So there's probably one thing. If you only had one option, the government said you can do one thing during the investigation stage. Mr. Terrace, what's it going to be? I'm going to invoke my client's right to counsel and their right to remain silent. I did include in here common and good language for an invocation of rights. So you can rely on that and you'll have the materials if you'd like. But this is a pretty all-encompassing example of an invocation of rights. So witness, subject, or target. This is a really maybe the most important aspect as far as fact finding and determining where your client is headed, where you're headed with your client in the federal criminal process. There's a lot of reasons why we want to know this. Just one of these, even just this one word, witness, subject, target, this moniker tells us so much about the nature of the government's investigation. So we want as much clarity as we can get here as possible. It really determines what the next weeks, months, years of your client's life could potentially look like, and your own practice as well, and what your next steps have to be. So this is like a very first question, I would say, maybe after timetable. When are you planning on moving forward with charges against my client? If you are, probably the next is, are they a witness, subject, or target? And it is so important, really, because it has a direct correlation to the likelihood that they will be either arrested or later charged with a crime, as well as the timetable of that. If somebody is a target, that means that the government has already established they're pretty far ahead if they've already determined. Just practice tip, I ask the prosecutor directly if they don't say it on the phone, or if it's a law enforcement agent you're speaking with. I'll say, one of my first questions, is my client a witness, subject, which is how in the federal system kind of a suspect, what's referred to as subject, or a target. So of course, at the one end we have a witness. If your client, and many of our clients who come to us fall into the witness category, because you can be contacted by a federal agent and they might just say, we'd like to speak to you about so-and-so scheme, about this Ponzi scheme. And you client might know, they might that they're just a witness to it. They might not know, because it is a legal distinction that's specifically defined. And there's also witness, people mostly think someone who has seen a crime occur, but in the federal system, it has specific terminology attached to it. And it also means a lot as far as we're talking about, why is this knowing where our client stands on this spectrum so important, is because one of the next things we're going to be talking about is what's the best way to, and how can we successfully keep our client from being charged. And we do that by keeping them from on the low end of this spectrum, ideally a witness or a subject, even if they are a target, keeping them one that might be able to, we might be able to get them successfully changed in the mind of the government, whether they'll classify it as an actual change or not, from going to a target to a subject. And that's, we have had a lot of success with that, and it's a definite goal for any representation during the investigative stage. So for a witness, it doesn't necessarily mean that you saw a crime happen. It could be that you know information about someone else that they're investigating, or that you've potentially also been the victim, kind of falls into witness as well. And they might not know that yet. The government might not know that yet. Your client might not know that yet. But even if you get a call, and if you're you're in federal criminal defense and taking on clients, and the client calls and they say, I got a call from somebody from the Office of Inspector General, the FBI, and they said, I'm just a witness, so they'd like to talk to me, and I don't really need a lawyer. Do I? Absolutely, absolutely. Because one, the government and agents are allowed to tell you you're a witness, with rare exceptions when you're not, when they believe you do know more, to entice you to speak to them. And it can definitely, at any point, it can change. You can go from a witness to a subject to a target, depending on that conversation that you have. And we have clients who come to us all the time that said, hey, they told me I was just a witness, so I went and spoke with them. And sometimes they can be subject, as we say here, to obstruction of justice or lying if they weren't completely truthful during that interview, even if they were a witness. Now they're something more, or they really had more criminal exposure than they thought they did. And these agents are usually very well trained at making people feel like they're just witnesses or maybe just subjects, because that's how you get them talking. Less people are going to ask for an attorney or say, I'd prefer to remain silent right now, if you tell them they're a witness as opposed to a target. So don't assume that just because a client says they're a witness that there's not more. You have to dig. You have to go further. So continuing, okay, on the other side of witness is target. And when a prosecutor or deems, with the help of law enforcement together, when they deem that somebody has been as a target, it means that they have substantial evidence already that that person has committed a crime. So when we're talking about timetable, like why it's so important, you can imagine that if prosecutor says your client's a target, especially if it's a financial crime, a white collar crime, or some sort of ongoing or long-term conspiracy, maybe over a period of months or years, that means that the government has been investigating them for some time. Sometimes that the government, whether it's the prosecutor or the investigator you're speaking to, if they say we haven't quite determined where your client is yet, well, one thing, it's a good thing to know or ask colleagues about the prosecutor, because they're not always as genuine as we want them to be. But that also tells us that they're earlier in their investigation. If they have targets already listed out, then we know that they're pretty far along, and we have to really, really get working. Subject is in between. So to federal prosecutors, to the Department of Justice, a subject is a person whose conduct is within the scope of a grand jury's investigation, meaning that they have relevant information. They could be suspicious. They do have some criminal exposure, but not enough for the prosecutor to be able right then and there to charge them or to ask or present to a grand jury information to charge them. They're digging more. And what we really want to do in that situation is go keep them or try and get them from subject down to witness, or from ever becoming a target. And we'll talk about some ways that we can do that. The DOJ Justice Manual is a really great resource. I had the link at the bottom there. If you go to the DOJ site, it's pretty much what what their internal directives are, and it's all public. And it defines these terms very well, so you can speak intelligently, your first day on the job, so to speak. According to the DOJ, a target is a person to whom the prosecutor or the grand jury has substantial evidence linking him to a crime, or in the judgment of a prosecutor is a putative defendant, basically that they're going to be brought in as part of a conspiracy, even if they're not the main individual that the government's ultimately targeting. The subject of an investigation is defined as a person whose conduct is within the scope of a grand jury's investigation, but they don't necessarily have substantial evidence just yet. So you want to do your homework, and you want to do it quickly, because you want to keep your client, if you get hired in the investigation stage and hired early enough, from ever getting to that target point. Can't always happen. Sometimes your client comes to you as a target, just like sometimes they come to you halfway through your case, and you just have to be able to adapt. So as I said, status can change. Don't get comfortable. Don't get complacent. Make sure that you are not, if you get a call or the prosecutor says your client's just a witness, don't just say thank you. Let us know. And sometimes there can be certain incentives to not create a situation where there isn't one, but don't promise your client something that you don't have actual factual information on. Still dig and still find out how can you get your client out of this. We don't want them being involved with the federal government. One way we'll talk about when we get to proffers in a bit is especially when your client's a witness or a subject, is being the first in, first out. That's what I say. First in, first out. And prosecutors often say that too. They'll call the client, and the client will say to us, well, the investigator or the agent said, hey, if I come in first, then I'm going to be best. And that's very often the case. Certainly for witnesses, and certainly for suspects, and potentially even targets as well. If you want to go in and you want to have what we're going to talk about as a proffer or cooperation session with the government prior to them bringing charges, you want to be the first one there, because they will not tell us. If we have a session with them and they ask about some other individuals, then we might learn. But a lot of times they will not tell you who else they've spoken to, because investigation is not public record. So you have to assume that they are talking to other people, and we don't know what that other person they're talking to is going to say about our client. I've definitely had cases where I had to sit down with the agents and the prosecutor, and they said, David, we have already kind of an idea that your client was really just a witness or had some involvement, but wasn't a leader of this conspiracy or anything along those lines. But several other people are saying that he was. So again, that's why you can't get complacent, and you have to act quickly when we're dealing with the investigation stage of a case. Again, major goal, getting in as early as possible before they've classified or made any ultimate decisions regarding your client. In reality, this might be out of our control. They might have already made up their mind. They might have had 10 other people come in and provide information, and they've built their case over a period of years, and there's no avoiding it. And then you just have to act accordingly. But you have to try. You can't just sit around in the federal system and wait for the arrest or wait for the probable cause affidavit. There's a lot that can be changed at this stage. I say at the bottom here, but I'll just finish here. Your client might have already come in, and Adam mentioned this. They might have already received a target letter, so we know that they're a target. They might already have received a subpoena to testify or provide information to a grand jury, which would suggest that they are more likely a suspect. Again, every case is different. Search warrant could be either. But some of these things might have already happened. We don't get to choose when our clients come to us for their help. I'm going to now be sharing my screen. So this is an example of what a target letter looks like, which is very common in our federal cases. Pardon my terrible redacting, but of course it must be done. But this is a case that we have. So client will, they don't all look like this, but client will receive a letter. Top, it says read federal grand jury investigation. And this letter is to notify you that you are a target of a federal grand jury investigation in the Southern District of Florida involving possible violations of federal criminal law, involves limited to conspiracy to commit wire fraud, bank fraud. And one of the ways that, even if you didn't know, a good tip is, let's say you didn't receive a target letter, but your client tells you, or you learn, or the agent or the prosecutor says, your client, we advise that your client bring counsel or have counsel, or we can appoint counsel, that means you're a target, because you don't have a right, and it's a case called Castigar that we'll talk about, but your right to counsel when it comes to grand juries and whether you can be compelled to testify or not really kicks in when you're a target. That's kind of getting a little technical and more than fundamental, but I wanted to show you what one of these looks like. You can see at the bottom, it says, if your counsel does not contact me, or you do not contact investigator Matthew Isman regarding appointment of counsel, I will assume you have elected not to resolve this matter at this time. In that event, the grand jury will consider the facts obtained during the course of this investigation. So again, this is what we're talking about when we say if somebody's already been designated a target, things could be moving pretty quickly. And that shows us that. And that's why we want to find that out as soon as possible, because not every target receives a letter. They don't have to send a letter, actually, unless they intend to try and compel your client to target in a grand jury. They really can't. Our clients would just take the fifth anyways. And another practice tip, this 14 days of receipt of this letter, very often the prosecutors are flexing their muscle when it comes to, we have a grand jury lined up. Get on the phone with the prosecutor as soon as possible. And here they're saying contact the investigator Matthew Isman. If there's a prosecutor involved, the investigator will direct you straight to have those kind of conversations with the prosecutor. I also wanted to show you here an example of a grand jury subpoena, a subpoena now. This was a case that was out of Massachusetts, but our client was in West Palm Beach. And some of the differences is you're commanded to appear in United States courthouse at this time to testify below the court's grand jury, or to, here it says, provide documentation. In lieu of a personal appearance, records may be produced on or before the date and time. If you have any questions, please contact the prosecutor. And then the prosecutor's information is down there. So more often than not, if your client comes to you having received a subpoena to testify or provide documentation, you can assume that it's not good to assume, but you can predict once you have the expertise and the comfortability to do so, that they're a witness or a suspect. Witnesses usually get less threatening subpoenas, or they're just called by an investigator. So again, federal government has a lot of tools at their disposal when it comes to an investigation that you have to know about and be prepared to deal with. Wiretapping, physical surveillance, monitoring online activity, controlled calls, or when they're having somebody who's cooperating with the government make a phone call and on a special phone and the government's on the other line, or it's being recorded. Subpoenaing bank records and financial documents, very common. Issuing grand jury subpoenas, which we talked about. Search warrants, very similar to if you've dealt with search warrants in state courts. There's not much difference there, other than the search warrants might be a lot more complex in a federal investigation. And conducting witness interviews and proffer sessions. So this, when we're talking about how do we achieve our goals in the investigation stage, is really a great time to transition into this very, very important concept in federal criminal defense, which is the concept of a proffer or cooperation. And it's not something that is very rare in state court. And it's an art, really. It takes a lot of practice, and it's good to speak to experienced attorneys about proffers, because they're some of the most crucial. aspects of a federal criminal case. So to proffer or not to proffer. And we'll talk about casting our letter and the protections that you get. So more or less, a proffer in the context of, well, proffer is a word that's used, defined, I guess, would be to provide something to someone or to provide information. So in the federal criminal defense context, it's one of the biggest aspects of our job. Is it's a offer for our clients to provide information and cooperate with the government, usually in exchange for some sort of benefit at sentencing and potentially no charges whatsoever. And that also depends a lot on where they are on that spectrum. Sometimes it's the only way to really gather the information that you need. It can be used as an investigatory tool by the defense, but you have to be very careful doing it that way because the government is not as smart as they seem, but they are smart. You might also hear this proffer referred to as a queen for the day agreement. Sometimes it's also called a debrief, and the best time to do it is early if you're going to do it, and we'll talk about why, but it could come at various stages, even once a prosecution has already started. So usually the U.S. Attorney's Office or Department of Justice Criminal Trial Division is investigating someone, and if they either think that your client has information that would be valuable for them to know, or if you learn that your client, from building that trust with your client, that they have valuable information, you want to set up a proffer session. Maybe other lawyers are different about this. I try and set up at least an initial meeting, proffer session, in every single case I have. Even if it's very clear that the client, the case is just about them. If they forged a passport maybe, and you'd think, well, what do they have to know? You never know. You never know. And sometimes prosecutors don't always think about it, about the possibility that your client has information. It's a tough concept to breach with the client, depending on the case, because a lot of clients refer to this as snitching. In state court, it's not very common. It's not always necessary. Pretty usually more cut and dry. This is the allegation. You have some wider investigations and conspiracies in state court, but especially in white collar and fraud cases in the federal system, organized crime cases, drug trafficking cases, and that's where things get a bit more dicey. You really, really want to have a heart-to-heart, so to speak, with your client about what they know. And sometimes that takes time. You have to build that trust. So they can happen, the actual meeting can take a lot of different forms. It can happen usually at the U.S. Attorney's Office. Sometimes it will happen at the FBI headquarters, wherever that might be in your district. And sometimes it happens at my office, at the attorney's office. Just depends on the circumstances of the individual case, and also how much protection, because these are under seal until they're not later, when sometimes they have to be disclosed, which we'll talk about. But your client is providing information, they're cooperating for a benefit. So I guess big question, why proffer? Why go out of your way to provide this information? How will it help me, and how will I be protected? Because in a proffer session, the very first thing, and you go in with your client, and let me stop there. Before you go in, you want to have prepared extensively with your client for this session for several reasons. You're trying to have your client give the most benefit possible, possibly be able to avoid charges altogether if the client or the attorney sometimes called an attorney proffer. You can go without your client, present information on behalf of the client, or the client presents information to show that they're not as culpable as the government thinks. They're not actually a target. They're a witness, or they're a suspect. But every single proffer session begins with what I basically call the truth serum phase. It's an audition. You go in and you sit down, and usually it's the defense attorney, our client, at least one agent, usually more investigators and agents, and at least one prosecutor, and sometimes more, depending on the nature of the information that's being sought. And the first meeting, and this is something, that is really, these are the kind of tricks of the trade that I think a CLE like this is so important about. The first meeting, or at least the beginning of the first meeting, is a truth serum. It's an audition to see if the government would even want to potentially use your client as a cooperator against a co-defendant, providing information that leads to other arrests and investigations in general. And so what they do when they start off, and again, my primary practice is in the Southern District of Florida, but I've had cases around the country, and pretty much standard across the board is they will ask questions, sometimes for the entire first session, which seems like a waste of time, but they have their reasons that they already know the answer to. So when you're preparing your client for a proffer session and you're deciding whether or not we should go in and cooperate, there's a lot of things to take into account. Most effective thing that I do, and that other lawyers who are my mentors and great federal defense attorneys will say, and that you should always tell your client before a proffer session, is if you go into the session and you want to provide information, and it's voluntary, they're not compelled, it's not under a subpoena, it's voluntary to try and help yourself by helping the government, is to assume that every single question that is asked of you, every single question that the government asks your client, tell your client to assume, presume, and just on the word of God, the government already has the answer to the question. Because if you can get that concept across to your client and they believe in it and they trust you and they can follow that, then there is no possibility that they will lie to the government. There's no possibility they will omit or exaggerate or minimize. You just answer the question that was asked, nothing more, nothing less, just what was asked, and just assume they already know the answer, because they usually do. And even if they don't, if you assume that they do, then you won't lie. And we're going to talk about why it's so important that you don't lie, other than obviously it's not good to lie to a federal agent, because there's specific consequences if you decide to proffer. Usually the first time, if you pass the audition and then you want a goal, is to have a second, a third proffer, maybe, if your strategy in a case is for your client to cooperate for their benefit. The attorney does play a large role in the proffer as well. Most of it is us sitting and listening, but a very important part is a very high intensity situation. I mean, your client is there, they're voluntarily giving information, and if they don't follow certain rules that we're going to talk about, then the immunities that we're also going to talk about shortly, so just some foreshadowing, that they're granted in order to feel comfortable or to be protected providing this information, are out the window. So a lot of times when I'm in a session, a debrief or a proffer with a prosecutor or with my client, with some agents, I ask to take breaks if my client needs it, or if my client has a question. They have to honor that. If the client says, I train them and we practice, we do a full run through, usually 4 or 5 hours, hypothetical situations. What signal should my client, say to me, or what should he say to me if he wants to speak in private? The prosecutors and the agents, I've had ones where there's been 30 people in the room. Every single one of them will gladly get out and they will leave the room so you can talk to your client. And they will not hold that against you. Sometimes the agents will ask questions or the prosecutors will ask questions that I don't feel are fair or that are likely to elicit a response from my client that just he didn't fully understand or that would lead him to omitting or minimizing. For example, if they say a prosecutor asks a question, tell me everything you know about the year 2021, or tell me everything you know about X company and your involvement in 2021. Well, should the client be talking about that for 3 hours or 30 seconds? And if they talk about it for 30 seconds, are they omitting? Are they minimizing? So I say no. You need to ask more specifics. Otherwise, this is not going to work. You can keep the prosecutors in check too, and don't be afraid to do so, or the agents if they're the ones that are asking the questions. Preparation for these is everything. One of the hardest parts about a proffer when you're deciding whether to proffer or not is the client, the start of any proffer session, even if it doesn't happen in the very beginning, it happens 10 minutes in, 20 minutes in, is whenever it is, your client has to accept responsibility in that proffer or the government will not use him. They'll say they won't use whatever he might have already said, he or she to that point against him, but they'll say, thank you, we're done here. So I've seen a lot of pitfalls. I had a client come to me where his lawyer didn't prepare him. They went to the proffer in a very big healthcare case, and my client thought that this was his opportunity to defend himself, to explain why the government was wrong. And apparently I wasn't there, but my client said it got very hostile. And from the very, very beginning, he lost trust. The defense lost trust with the prosecutors. It's hard to recover that. Takes a lot of experience and knowing how to recover it. But it can be done. But you want to start off the right way. So a proffer is not a chance for the client to come in and say, I'm innocent. It's not what it's for. It's to accept responsibility, be truthful, and then gain a benefit from doing it. And we'll talk about those benefits. But before we do, probably thinking, well, if a client comes in with you and he accepts responsibility, these usually happen in a perfect scenario. They happen before he's been charged. So isn't he just voluntarily confessing? David, I thought you said he should not give up his right to remain silent. That would be really bad. So in a proffer, okay, and this is another huge role of the defense attorney, and one of the most important parts of a case, if you can achieve and can persuade the prosecutor to give your client the opportunity to help themselves by cooperating, they provide something called a castigar letter, or a queen for the day agreement, they call it, or very often a proffer letter. And you'll want to read the case of Castigar. It's a great case. And it basically, what that does is it provides a form of conditional immunity. And there's different kinds of immunity. For the most part, I could talk about proffers for 5 hours. And we have other topics to get to because they're so interesting and they're so important. But really what use immunity is and what this conditional immunity is if you're being truthful, if you're not omitting, if you're not lying, and if you're not embellishing or exaggerating or minimizing your role, if you're following the requirements that your attorney has explained to you, and the prosecutor always says at the beginning too what is required of them. And we've already gone through, and I'm going to show you an example of the letter, but it lays it all out right there in the letter. If the requirements have been followed, then whatever your client says, okay, during that session cannot be used against your client at any stage. Okay, and that's really important. Really, really important. There's a caveat to that. It's with an asterisk. And there's a few things that can change that. One is if your client lies. Okay, if your client lies, whatever he or she has told the government during that session, it can be used against them. That's why you have to, developing the trust is so important there, because before I go into a proffer session, I have to know everything my client is going to say. Because if I don't know he's lying or she is lying, or omitting, if I have a good prosecutor and they have good relations, then you'd hope that they would say, let's take a break for a second, Mr. Terrace, can you stay and I'll ask your client to step out. I also will regularly during a session ask to take a break and will ask the prosecutor, are we good so far? Has there been anything that you've found that my client, based on the information you already have, which I know you have, that he has violated the terms of this agreement, of this session today so far? For the most part, at least in the Southern District of Florida, they will stop it. They're not malicious, and it can become a big issue later if they know your client is lying and then they elicit more testimony from him, knowing later that they're just going to say, oh, he lied, so now I'm going to use it against him. They're better than that for the most part. But again, that's always been my experience. I have had cases where federal prosecutors can really take some liberty, so you have to really be on your toes. And if you don't think that your client can follow those terms, or he isn't ready to, or he's very hesitant, then don't do it. It's not worth it. Other ways that your client's statements could, or he could lose that immunity, that use immunity. And we say use immunity because it's them using statements against his own statements against him, to either build charges against him, new charges, or to make sentencing worse, to use against my client at trial. They can't use any of those. That's use immunity as long as he is following the terms, and we're following the terms of the letter of the proffer agreement. Now, if your client also does decide to testify, because you can proffer and you can still go to trial. You can still say, we're fighting this. Thank you. We've told you what we know. But your client can't testify if you've proffered. If your client testifies at a trial, and technically the client could testify, but if they've proffered, we've only gotten through a proffer because they have essentially confessed. So you just really wouldn't put a client on the stand at trial, because if they were consistent with their proffer, then obviously they would be saying, I accept responsibility, I did something wrong. So they can't testify. And if they did decide to testify after a proffer, they could be hit with an additional charge of obstruction of justice, which is no good. Something else, one other area is called derivative use immunity. Derivative use immunity, and these are really the three ways that you get immunity, or don't. But derivative use immunity basically means that if your client gives information during the proffer session that's protected, and that information leads them to a source, okay, to another individual, and they speak with that individual, and that individual provides his or her own information about your client, we don't get to go back and say, well, you can't use that because my client told you that too. If the government can establish that they learned it from an independent source, it's complex. I could talk about it more. There's a lot of case law on derivative use immunity. It's highly litigated, but just know that the immunity is conditional, and you really, before agreeing to a proffer, you want to do your research or talk to an experienced attorney about the types of immunity that can be conferred. So I'm going to show you an example of a recent proffer letter. So this is a very good example of a proffer agreement. Each district does them differently. For the most part, they're the same, but there's a few crucial things that you want to have in there. This is, and the defense attorney, we can negotiate what's in the proffer to an extent, but it's very limited. Certain key things we need to have in there. So obviously there's redactions. First and foremost, the witness will answer honestly, truthfully, and completely. Does not in any way agree. This oftentimes says this is not a co-op. This paragraph 2 will say this is not a cooperation agreement. Okay, this is not an agreement in any form that says if you proffer to us and you're truthful and you provide valuable information that we're guaranteeing you any benefit in return other than you have immunity for what you've told us, and we'll see where it goes, basically. And you want to try and get to the next proffer session and keep it going to a point where if it's in your client's best interest to then actually cooperate with the government. And then you can get into more what we call cooperation agreements, which is when you really start talking about what kind of better deal can we get, potentially full immunity from a charge if you get in early enough. That's called transactional immunity, you'll see, and it's very, very, very rare. But again, it depends on where your client falls too. If it's a witness or a suspect, maybe you can get it if you've done great proffer. In this case, actually, it was a target. They called a witness, but it does depend, again, why that spectrum is so important. So paragraph 2, they say, we're not making you any promises. Paragraph 3, I love this language. It's not as good as a language as we usually get, but this is what I propose. Unless specified otherwise, no statement made by the witness during this will be offered against the witness in the government's case in criminal chief in any criminal prosecution of the witness or an aggravation of the witness's sentencing for the matters currently under investigation in accordance with sentencing guideline 1B1.8, except in a prosecution for false statements, obstruction of justice, or if they've lied during the proffer or otherwise omitted or minimized or violated the terms of the letter. So practice tip, any proffer letter that you have to make sure that it mentions sentencing guideline section 1B1.8. This is the guideline that talks about what the government prior to a sentencing will provide to the probation office. I don't want to jump ahead too much, but when we get to sentencing, probation office and what they provide to the judge prior to a sentencing based on something called the pre-sentence report or pre-sentence interview. They have it in state court as well. It just happens in every federal case unless you have had a case dismissed by a motion or not guilty or other means. There will at some point be a pre-sentence requirement investigation for felony cases. And this guideline here, this letter, it's not in every letter, but it does basically say that whatever was said during this proffer session cannot be given to, or will not be disclosed to probation, because probation is an arm of the judge. And the judge, whatever probation has of the court, whatever probation has, the judge can have too. There's no immunity or no privacy there. So why is that important? That line basically means your sentence can't get worse if probation learns about this and discloses this information, where it could be very damning against yourself, but you're doing it to help yourself, so that the judge doesn't know at sentencing. So 1B1.8 is really important to have in here. Paragraph 4 is about derivative immunity. We talked about obtaining leads. if your client testifies, we talked about at trial or otherwise, then what has been said in the proffer can be used for impeachment. They can be cross-examined with it if their statements are not consistent with the proffer, which they never would be. Otherwise, we're not proffering. Which we don't always do. If we want our client to be able to preserve the right to testify, it's important to our defense. And this appears to be a case that looks more like a trial case, then proffer is not common, especially if we believe it's crucial to our defense to have the client testify. The witnesses waive any right. This line here, 6, is talking about these codes. The Castigar case is whittled down to these codes. You can read the case, and they're not going to be recorded. No additional promises, agreements, or conditions entered into, and none will be entered into unless signing of the party. And the assistant United States attorney signs it, the agent who is present signs it, the attorney being me, and the client signs that. So that's the Castigar letter.